Hello everyone, U.S. Immigration Attorney Michael Ibrahim here. Today, I'd like to talk with you guys about a common theme in the immigration practice, when USCIS wants more. These are known as requests for evidence, or RFEs, notices of intent to deny, or NOIDs, or N14s, notices of continuances, in citizenship cases. Quite often, the individual will apply for a USCIS benefit thinking they'll either get a yes or a no in adjudication, but that's not often the case. Let's discuss each one of these notices individually. First, a request for evidence, or an RFE. I'd like to think of this as USCIS saying, we want to approve your case, but we just need a little bit more. Sometimes this can just be one document, like a missing birth certificate. Other times, it's a string of documents, or perhaps a common theme that's missing in your initial application. In my experience, responding to these properly will more often than not lead to an approval. On the other hand, a notice of intent to deny, or a NOID, N-O-I-D, is USCIS saying, we're looking to deny your case unless you prove otherwise. In my experience, these must be responded to strongly with a legal argument articulating why you believe your case should be approved, along with the corresponding documents and evidence proving your case. What I've seen more often than not in a NOID is a denial, regardless of how strong your response is. Bear in mind, even if USCIS denies your case, you always have a remedy of asking for a second opinion through an appeal, a motion, or in some instances, federal court litigation at your local district court. Keep in mind, USCIS gives you a timeline in these cases. In my experience, I've seen USCIS issue a request to be responded to in as little as 14 days, but more often than not, you're looking at about 33 days, upwards of 83 days. Due to the COVID-19 global pandemic, USCIS has given applicants extensions of upwards of 60 days in certain notices. When you receive a request for evidence or notice of intent to deny, the first thing to do is to not panic. Like we discussed, quite often, a strong response to these notices will lead to an approval. Next, strategize and game plan. Take a look at what the notice says and what it's asking for. Take a look at specific documents that it's looking for and common themes that the immigration officer wants to hear back from you. Next, game plan. Think about what evidence is missing and how you can overcome that request. Compare it and compartmentalize it with what you already submitted. Finally, prepare a strong response with ample documentation and sometimes a legal argument. Are you or a loved one in receipt of a request for evidence or notice of intent to deny? Don't panic. Call Ibrahim Law Office and schedule a consultation for us to review your notice today.